5 seconds to go. Start. Indisputably, the period of 10 years may relate to the period prior to 1st December 2019 or thereafter. In other words, it provides that the activities which were offences under the law in force at the relevant time and in respect of which two charge sheets have been filed and the court has taken cognizance thereof during the period of preceding 10 years, then it will be considered as continuing unlawful activity on 1st December 2019 or thereafter. It nowhere by itself declares any activity to be an offence under the said 2015 Act prior to 1st December 2019. It also does not convert any activity done prior to 1st December 2019 to be an offence under the said 2015 Act. It merely considers two charge sheets in relation to the acts which were already declared as offences under the law in force to be one of the requisites for the purpose of identifying continuing unlawful activity and or for the purpose of an action under the said 2015 Act. If the decision of the coordinate bench of this court in the case of Shiva alias Shivaji Supra is looked into closely along with other provisions of the Act, the same would indicate that the offence of organized crime could be said to have been constituted by at least one instance of continuation apart from continuing unlawful activity evidenced by more than one charge sheets in the preceding 10 years. We say so keeping in mind the following. If organized crime was synonymous with continuing unlawful activity, two separate definitions were not necessary. The definitions themselves indicate that the ingredients of use of violence in such activity with the objectivity of gaining pecuniary benefit are not included in the definition of continuing unlawful activity but find place only in the definition of organized crime. What is made punishable under section 3 is organized crime and not continuing unlawful activity. If organized crime were to refer to only more than one charge sheets filed, the classification of crime in section 311 and 312 respectively on the basis of consequence of resulting in death or otherwise would have been phrased differently, namely by providing that if any one of such offence has resulted in the death, since continuing unlawful activity requires more than one offence. Reference to such offence in section 3.1 implies a specific act or omission. As held by this court in state of Maharashtra versus Bharat Shantilal Shah Supra, continuing unlawful activity evidenced by more than one charge sheets is one of the ingredients of the offence of organized crime, and the purpose thereof is to see the antecedents and not to convict without proof of other facts which constitute the ingredients of section 21E and section 3, which respectively define commission of offence of organized crime and prescribe punishment. There would have to be some act or omission which amounts to organized crime after the act came into force, in respect of which the accused is sought to be tried for the first time in the special court, that is, has not been or is not being tried elsewhere. However, we need to clarify something important. Shiva alias Shivaji Supra dealt with the situation where a person commits no unlawful activity after the invocation of the Makoka. In such circumstances, the person cannot be arrested under the said act on account of the offences committed by him before coming into force of the said act, even if he is found guilty of the same. However, if the person continues with the unlawful activities and is arrested after the promulgation of the said act, then such person can be tried for the offence under the said act. If a person ceases to indulge in any unlawful act after the said act, then he is absolved of the prosecution under the said act. But if he continues with the unlawful activity, it cannot be said that the state has to wait till he commits two acts of which cognizance is taken by the court after coming into force. The same principle would apply even in the case of the 2015 Act with which we are concerned. In the overall view of the matter, we are convinced that the dictum as laid by this court in Shiva alias Shivaji Supra does not require any relook. The dictum in Shiva alias Shivaji Supra is the correct exposition of law. With the aforesaid clarification, the appeal stands disposed of. We are of the view that the same would be in tune with the dictum as laid in Shiva alias Shivaji Supra, that there would have to be some act or omission which amounts to organized crime after the 2015 Act came into force, that is 1st December 2019, in respect of which the accused is sought to be tried for the first time in the special court. We are in agreement with the view taken by the High Court of Judicature at Bombay in the case of Jai Singh Supra, that neither the definition of the term organized crime nor of the term continuing unlawful activity nor any other provision therein declares any activity performed prior to the enactment of the Makoka. Stop.